Okay. Good afternoon. Thank you, organizers, for the invitation of the conference. My topic is Standard of the Protection of Human Rights of Patients in Psychiatric Hospitals. And I want to make some general remarks in the perspective of a few judgments of the European Court of Human Rights and the protection of human rights of patients in psychiatric hospitals. There are very rare provisions in commonly binding law related to the protection of human rights of mental patients and at European or international level. Of course, we have the Convention with Disabilities and, like you see, for example, Article 7 of the Convention on Human Rights and Biomedicine, but this provision is dedicated only to the problem of consent of persons who have a mental disorder. But from the perspective of the protection of human rights, I think that the most important is the protection of right to liberty of a person with mental disability, because I think it is quite obvious the involuntary placement in the psychiatric hospital should be treated as an example of the deprivation of liberty, of course, because of preventive reasons, some preventive reasons. And we can make a question: what kind of factors, what kind of circumstances should be met to assess the involuntary placement in the psychiatric hospital as an act which is in accordance with the law and which is justifiable from the perspective of the protection of liberty of this kind of person. Firstly, the scope of application of the human rights standard made by the European Court of Human Rights is very, very wide. Why? Firstly, because the court uses very wide interpretation of the term without consent, showing what kind of examples should be treated as a deprivation of liberty. And it's not only situation when a patient doesn't give a consent for admission to the hospital, but also those situations in which the consent was given, but not exactly by the patient, by other persons, like, for example, guardian in fact, a legal representative, even a court. So very wide interpretation, what means without consent. Secondly, there is also wide interpretation of the judgments of the European Court of Human Rights of the term deprivation of liberty, because a placement in a locked room or a placement in the closed ward is not necessary to assess the situation of a patient as a deprivation of liberty. The best example, for example, is in the case Atudorei against Romania, when a patient was placed in the hospital on an open ward, can freely leave the hospital, but there was one very important factor. This hospital was located in a remote area, and there is no possibilities to leave this area by the patient. Very important factor, but which can lead us to the conclusion that this should be the perspective of deprivation of liberty. Standard of the protection. The standard of the protection of human rights should be related to two issues. Substantive law, and this substantive law should establish the criteria of a placement of a patient in psychiatric hospital, and procedural law, so the procedure of the placement, because we need also to protect the rule, for example, of a fair trial in the very wide scope. The substantive law. In the perspective of substantive law, I think that there are two issues which should be regulated to good protection of a right to liberty of mental patients. Firstly, the state of mental health which give the opportunity to place someone in the psychiatric hospital without his consent. And in this area, countries have very wide margin of appreciation. And secondly, I can say the risk or maybe the danger resulting from this mental state of health and the values connected with this risk, which the country, the state, want to protect through the involuntary placement on the psychiatric hospital. This is this second expression. So the mental disorder must be of a kind or degree warranting compulsory confinement. And I think that nowadays we can make very important questions. What kind of values should be protected by involuntary placement of a patient in psychiatric hospital? As we see in the judgments of the European Court of Human Rights, this is the point 146, the court rather states that this should be health or life patient of other persons. So this group of values is very often limited to this very important, of course, values, but we can make a question whether or not this kind of limitation is justifiable. Why? Because we have huge development in the medical knowledge. We have better possibilities to predict the behavior of the patient. And there are, in the public debate, from the perspective of public opinion, some values which also should be protected by involuntary placement in psychiatric hospital. The best example, sexual freedom. Sexual freedom of a victim. But of course, we can try to show another values which maybe should be taken into account in the near future. Freedom from threats. Very, I don't know, discussable thing, valuable property, maybe. There is an open question, what kind of values should be protected during the involuntary placement of patient in psychiatric hospitals. Second aspect is connected with procedural aspects, so the procedure of a placement in involuntary in psychiatric hospital. Firstly, for me, I think, very important is the role of the court. As you see in the judgment VARBANOV against Bulgaria, the court made some statements about the role of experts, medical experts, in the procedure of involuntary placement of a patient in psychiatric hospital. And the court states that a general rule should be always prior opinion of medical expert, and only in urgent situation this opinion can be received after the act of deprivation of liberty. I think that the same rule can be adopted to the role to the court, although this role of the court was not expressed in details in the judgment of the European Court of Human Rights. What I mean, that the general rule should be that the court should give a prior authorization for every placement of a patient in psychiatric hospital, and only in urgent situation this decision can be made by a physician, and the court then in the near future should authorize the decision made by the physician. Secondly, the obligation of medical experts. The court underlined many times that in the perspective of Article 5 and Article 6 of the Convention, we should protect the right to fair trial, and we should guarantee neutrality of medical experts. And this neutrality of medical experts means, for example, that during the procedure before the court, and this procedure which should lead to the authorization of a placement of a patient in psychiatric hospital, we should receive the opinion of the expert from a different place than a patient now is placed. And in practice, sometimes it is very difficult to receive such an opinion. For example, when we have a city or an area when there is only one psychiatric hospital. And there is a huge conflict, because on the one hand, we should protect, for example, speed of proceedings and, of course, the exclusion of unnecessary deprivation of liberty. But on the other hand, we want to have the neutrality of the experts and the protection of the rule of the fair trial. For example, in Poland, there are very rare situations when an expert from the same hospital where the patient was placed by another physician makes a different opinion than this former physician. And thirdly, periodic review. The state of the health of a patient should be evaluated during the whole procedure of involuntary placement in the psychiatric hospital. And that's why in many judgments, European Court of Human Rights stated that a state should guarantee the periodic review of the state of a patient and the necessity of further stay of this patient in the psychiatric hospital. But of course, this necessity of periodic review, which should be made by the court, I don't know, 6 months, every 6 months, does not solve the problem of periods of time between the evaluation. And during the period of time of 6 months, this is huge period of time, the state of health of a patient can change. That's why, in my opinion, this periodic review, the necessity of periodic review of the state of the health of a patient does not guarantee that the patient will not stay longer that is necessary from the perspective of his health and the protection of other values. That's why, for me, there is an open question, what can we do in the future? What kind of legal mechanisms can we introduce in the law to give the courts better possibilities to evaluate the state of the health of a patient, not only every 6 months during this mandatory periodic review, but also in periods of time between these evaluations. Thank you very much.